cases, either wife or husband want divorce, the other party doesn't want divorce. Okay, so it is very difficult to prove the allegation that is there in that particular ground. The husband or wife has to prove strictly whether it is a case of adultery, it is a case of reality, and on the strict proof, and the degree of divorce will be granted or not. But this is a very safest rule that divorce by mutual consent, if the parties, both the parties come together and they say, let us part happily. If such a tendency is there between the spouses, then they can simply make an application that they don't want to live together. They have been living separately for 1 year and there is no pollution between them and they want divorce. The court is also not bothered about who is at fault. Why you want divorce? Nobody. The court is not interested to prove. If both of you come together and say, yes, we want divorce, we are here to grant divorce. But 6 months waiting period is there. The first petition they will come, the court will say, you come after 6 months. This 6 months period is a cooling period where there may be a change in the mindset and there may be a withdrawal of mutual consent. Okay, so this is one thing. And now, when the RCR or judicial separation has been already granted, it is prevailing. Suppose the wife has withdrawn from the conjugal society, husband filed a petition for restitution, he got restitution, and now the wife is not willing to come and join with the husband. Can a woman be forced as a cattle to come and join with the husband and to have a forced sexual union or cohabitation? This is one important point. Wife is not a chattel. Wife is not a cattle. If she wants, the owner of the cattle will go and find out, trace the cattle and bring the cattle back home and tie it, whether the cattle likes it or not. And here, this restitution of conjugal rights, if it is in limbo, that means marriage is in limbo, then minimum 1 year waiting period, the law says, even after restitution of conjugal rights or even after the judicial separation, if you are not able to live together, and both of you, either of you is free to go for divorce. Okay, so this is called breakdown of marriage. Even the first innings have been fought in the court. One party has won, but not able to preserve the marriage. So there is a stepping stone. So that is the breakdown under section 13(1)(a). Here, there are some cases where the parties have not approached the court or they might have filed many complaints against each other. The fault is at the both of the parties or both of the parties are justified in their own term. Okay, the court is not find out who is at fault. But the court says both are at fault. Both these cases cover under irretrievable marriage, breakdown of marriage. That is, the previous one is just breakdown of marriage. And the second one is irretrievable breakdown of marriage. It has not been a ground for divorce because, like 498A, there is a possibility of the wife to misuse it. This irretrievable breakdown of marriage, if it is given as a ground, there is every chance that husband has the scope of misusing this and get divorced very easily. So the law wants to balance the interest of both. So it has not kept this irretrievable, and here where the marriage is emotionally dead, there is no thorn, there is no roses but only thorn only, and there is no purpose in the marriage to keep it alive, then the court says it is better we will dissolve the marriage. So here only the Supreme Court alone has got the right under Article 142. If you just come to divorce under Muslim law, and divorce has been termed as talaq. So talaq is a most detestable and debatable topic under Muslim law. And you might also heard that Supreme Court recently has struck down triple talaq as an unconstitutional form of talaq. So here husband can divorce his wife by pronouncement of talaq. Three types of talaq is permitted under customary law, because I said that it is not a codified law. Under customary law, he can pronounce. And he can just sit at home, he can pronounce talaq. And the wife's presence is not required. He need not also communicate the factum of talaq to the wife. He need not go to the court and prove any allegation against the wife. It is a prerogative of the husband to say that if I don't like the wife, then I can pronounce talaq. So this is the arbitrary form of talaq that has been followed by the Muslims. And here, talaq hasan is one talaq during the tahar period. That means tahar period is a period between two menstruation cycles. The husband will pronounce talaq, and it will be followed by another 3 months of non-abstinence from sexual relationship between husband and wife. On the expiry of third month, the talaq becomes irrevocable. The talaq becomes final. This is talaq hasan. Then the talaq hasan. During first month, he will pronounce the talaq, followed by sexual abstinence. Second month, he has to follow the second pronouncement, and the third month, he has to follow the third pronouncement. And after the third pronouncement, the talaq becomes irrevocable and irreversible. Then the marriage ends. So this is the second type of talaq. The third type of talaq that is very commented upon is that triple talaq and talaqul bid'ah. This has not been approved even by prophets. It has not been mentioned in Quran. But because of some popular customary practices, out of convenience, and men folk in the Muslim community belonging to fundamental category, that is fundamentalist, we call them as fundamentalist, and they have adopted this triple talaq, at any one point of time say thrice, talaq, and not necessarily orally. He can nowadays, with the advancement of technology, over phone, over fax, over internet, and over mail also, that message is, if it is given, then the talaq is over. This form of talaq has been found to be most arbitrary. It has been challenged in Shaira Banu case. In Shaira Banu versus Union of India, 2019, and the court said, we cannot accept it because it is a sin committed by a man against a woman. It is not recognized even by Prophet, and it is unknown to Quran. But since it is only a human practice and it is derogatory to the human, that is women's rights, because the most important thing is that the heinous part of this triple talaq is that suppose he pronounces talaq today thrice and the marriage is over, okay, and he is no more a husband, but even in intoxication he did it, or just like a jest, okay, out of play, he says triple talaq, then the marriage is over. Suppose he regrets tomorrow that I should not have pronounced triple talaq, then there is one derogatory practice that has been followed by the community, that wife has to undergo that halala marriage. Halala marriage is nothing but it is an intermediary marriage. The divorced woman, and she has to marry another man. That marriage should be consummated, and that marriage should be broken either by way of death of the second husband or by way of talaq. Then this man can freely marry that woman. Okay, this is called halala practice. This has been human rights, women's rights groups, human rights things, they have strongly condemned, and it took such a long time. In 2019, Shaira Banu case, she has been triple talaq by the husband. Even the ladies of 70 years, 65 years old, they have been triple talaq by the husband. And the worst part is that after talaq, the law says the man need not maintain the woman. And only during the iddah period that she has to follow 3 months after divorce, the husband has an obligation to maintain the wife. Then afterwards, and it is the duty of her parents, it is the duty of her children, or ultimately if nothing is possible for her, she has to go and apply in the work board to get maintenance allowance. So the maintenance law and the talaq law is very, very weak under Muslim law. Okay, so this is one thing. And but if wife wants divorce, she cannot pronounce talaq, and she has to go to the court. She has to prove the ground of fault, matrimonial fault committed by the husband. So this is very discriminatory practice. And there is one act, Dissolution of Muslim Marriage Act, and I don't want to go to the details of definition, etc. And husband neglected to maintain her for 2 years and did not perform marital obligations for 3 years and not being heard of for 4 years and has been sentenced to imprisonment for 7 years for any offence, and he has been insane for 2 years and he is impotent since the marriage and he is suffering from many communicable diseases and treated her cruelly and discriminately, and then she has exercised her option of puberty. Option of puberty means if her marriage has taken place before her 15 years, the marriage age for all or 18 for girls and 21 for boys. But according to Muslim law, the marriageable age is 15 years for both boy and the girl. And that is the age of puberty we call. So if any marriage takes place before 15 years, then the consent of the guardian is a must. Their consent is irrelevant. But after 15 years, their consent is relevant, the consent of the guardian is not relevant. So if at all her marriage, her or his marriage takes place before his or her 15 years, and there is a law that, and in this case it is a ground for wife. If her marriage has taken place before 15 years, she can exercise that option of puberty and get relief from the marital bond. And talaq-i-tafwis is one unique feature that husband at the time of marriage or any time after the marriage, he will delegate his power of talaq to the wife. Suppose the husband says, that is the wife can put, because you see, in Muslim law also there are many safety nets that are provided for Muslim women. But most of the Muslim women, they do not know the law. And here she can put a condition on the amount of dower. At the time of marriage, dower is not dowry, and dowry is prohibited under Dowry Prohibition Act, but dower is legally valid according to the Muslim law. Dower is nothing but dower or meher we call it. The husband has to pay to the wife at the time of dissolution of the marriage. So, dower is, if she is capable, she can say that I want 10 lakhs as dower. So, at the time he pronounces talaq, he has to shed 10 lakhs to the wife, and then only he can pronounce talaq. So, these are certain conditions that are enabling the wife also, but most of the women, they do not know the law. Okay, and there may be peer pressure and also there may be parental pressure that if you put condition, marriage will not happen. Okay, so here dower is one tool, important tool, and here tafwis also is that where she can say, if you don't treat me equal with other wife, if you take second wife, if you neglect me, then you must delegate this power of talaq to me. Then, if the husband says yes, he will delegate the power and she will exercise talaq, and she is not exercising the talaq against the husband, she is exercising talaq against herself, that as if the talaq that is pronounced by her is pronounced by the husband because she got it with the authority of the husband to talaq. Okay, that is one important provision, talaq-i-tafwis. Under delegated authority, also talaq. This is the only occasion where the wife can pronounce talaq with the authority that is given by the husband. So it is for the woman to be prepared for all any occasion in her life, and she should be very, very capable of placing some conditions. Okay. And Kula and Mubarak by mutual consent. That means the husband says, the wife says, I want, please relieve me from the marital bond. Then husband will put a condition. You forego the entire dower amount, or you forego 50% of the dower amount, and she says, it is better I go out and even I don't claim the dower. So it is beneficial for the husband. So here remission of dower is possible, or forgoing of dower is also possible, and here it is divorce by negotiation. Okay, but ultimately he will give the consent. Okay, Kula and Mubarak. And here implications of divorce. And here the implications are very harsh for a Muslim woman rather than a Hindu woman. Wife has to follow iddat, and this iddat period is a period of seclusion. She will not associate herself with any social activity. This iddat period is nothing to, it is none other than to prove that she does not carry the child of that man. Okay, later on, the paternity of the child should not be a crux of conflict. So this iddat period is a period whether she is carrying the child or not, whether she is pregnant or not. So after the iddat period, both are free to marry. Okay, so this iddat period is a must. And then husband has to maintain her during the iddat. She must be paid her meher and doyer and no mutual inheritance like any other divorced woman. So now domestic violence, it is a social pathology. We cannot trace the origin of domestic violence. It is a universal phenomenon. It is not confined